assisting your Assembly President with responsibility for finance, Dr. Ashley Singh. We have the Honorable Member, Ms. Susan Rodriguez, who also will be here with us virtually all day. We have the Honorable Member, Mr. Christopher Jones, with us at the moment. Honorable members, we will now proceed with the second reading of the Law Reform Commission Amendment Bill 2020, Bill number 11 of 2020, published on the 20th of November 2020. Honorable Attorney General and Minister of Legal Affairs.
Thank you very much, Mr. Speaker. I rise to move that the Law Reform Commission Amendment Bill number 20, Bill 2020, number 11 of 2020, published on the 20th of November, be now read a second time. Mr. Speaker, this bill deals with the establishment of a Law Reform Commission, rather the composition of the Law Reform Commission already established by law, and the criteria, the qualifications of persons who will constitute this commission. A Law Reform Commission, Mr. Speaker, may be defined as an independent body established by government to consider the state's laws and make recommendations or proposals for legal changes or restructuring. Most Commonwealth jurisdictions have such a commission established, and they play a crucial role in driving the law reform process in a proactive, institutionalized, and methodical manner, thereby dispensing with ad hoc, reactive law reform. A law reform commission in most of these jurisdictions also engages in law revision, which is a completely different legal process from law reform. Law revision entails the updating of the laws by insertion of amendments and new enactments, along with accompanying regulations in consolidated volumes of the laws at periodic intervals. Mr. Speaker, the Law Reform Commission is admittedly late in coming in this jurisdiction. A few years ago, I recall a motion being put to this Honorable House by the late Honorable Miss Deborah Backer, in which, in that motion, the Honorable Member called for the establishment of a Law Reform Commission. The then Attorney General, Mr. Dudnath Singh, Senior Counsel, had explained that the reason why the government of the day was not going to move in the direction of a Law Reform Commission at that point in time was that we were then engaged in a law revision exercise. Recall, Mr. Speaker, that the last complete and comprehensive law revision exercise took place in this country between the years 1974 and 1977. And after a very long hiatus, then we commenced another one, which was concluded by 2012. So at the time when that motion was put to the floor and was being debated, we were in the middle of that law revision exercise. And it was explained by learned senior counsel, Attorney General Mr. Dudnot Singh at that time. And we all concurred with that position on this side of the House then, was that when the law revision exercise would have been completed, then we would move to the establishment of a law reform commission. We have completed, Mr. Speaker, as you are well aware, that law revision exercise. Mr. Speaker, the establishment of a law reform commission in Guyana is a component of an inter-American development funded project under the rubric Assistance to Criminal Justice System. In 2016, in this Honorable House, the Principal Act was passed. In opposition, we welcomed the concept of the establishment of a law reform commission. We were vehemently critical, however, of the appointment process and the manner in which the commission was constituted. And we expressed those sentiments of opposition to the bill in the debates. Of course, Mr. Speaker, we were ignored and the bill was passed. In 2017, 2018, and 2019, huge sums of money were budgeted for this commission. A building was rented for all these years at a cost of $800,000 per month. 10 clerical staff were appointed and paid for all these years. A new vehicle was acquired with a chauffeur hired. And this commission consumed in excess of $100 million, but no commissioner was ever appointed. Mr. Speaker, this constitutes once again another manifestation of a colossal waste of taxpayers' dollars characterizing the APNU-AFC style of governance. In direct contrast, Mr. Speaker, as soon as we assumed office, I caused the rental contract to be terminated, immediately saving this nation $800,000 per month, along with light bills, phone bills, internet bills, etc. Mr. Speaker, when we examine the credentials of the staff, one person who only has an LLB degree was hired and paid a whopping sum of $750,000 when compared with a fully trained attorney at law attached to the AG chambers who earns less than $300,000 Guyana dollars. This is another feature which characterized the previous government. Mr. Speaker, we could have terminated the employment of all those persons, but we did not. And many times we are accused, Mr. Speaker, of witch hunting and of terminating employment and putting people on the breadline. And here it is, Mr. Speaker, that we could have easily done that. We could have easily done that in this commission because there was no commission, there was no commissioner, and the commission existed on paper only, while it had 10 staff and chauffeur, etc. But we did not do that, Mr. Speaker. What I did instead was to employ all those persons as clerks within the ministry, and of course, adjusting their salaries to bring them in conformity and consistency with the range of emoluments enjoyed by persons of that status at the Attorney General chambers. These clerks, these typists were earning $200,000 per month at the Law Reform Commission. So they were earning as high as the State Council or just below State Council. But we did not pasture them. We brought them back within the ministry. We adjusted because they were all employed on contracts. I hear the Honorable Tabitha Ali speaking and glorifying about public officers. And all these officers they were hiring on contract. She is now pleading a case for public servants when their administration hired more persons to work in the public sector than on contracts than at any other period in our history. So these contracts that they were operating under were terminated and or adjusted to bring them in conformity with public servants' salaries. And up to date, they remain employed within the Ministry of Legal Affairs. Mr. Speaker, with the kind courtesy of my colleague minister, the Minister of Youth and Sport, the Honorable Charles Ramson, I was able to secure accommodation within a building over which that ministry has ministerial responsibility, located at Middle Street, free of cost, where the Law Reform Commission, once established, will be accommodated. Mr. Speaker, as I indicated, our objections to the Principal Act were twofold: the appointment process and the qualifications of members. Under the Principal Act, Mr. Speaker, the President made all the appointments after consulting only with his Minister of Legal Affairs. No one else was consulted in the process. And all the persons appointed to that commission were persons possessing legal qualifications only. Mr. Speaker, and that is what we found significantly objectionable. One, the President, acting only upon the advice of his minister, appoints all the commissioners. And the persons who are considered for appointment, or rather only persons with legal qualifications, are qualified under the law to be appointed to this commission. That, Mr. Speaker, we considered to be a most myopic, flawed, and strange understanding of the nature and function of a law reform commission. Mr. Speaker, in principle, there is absolutely no basis to concentrate all these powers in the executive without an input from any other sector of the country. Mr. Speaker, laws are made for the benefit of all of us in a society. The law is not made for one section of the society. Or if a law is made for one section of a society, then the lawmaking institution must be equipped to deal with the peculiarities of that segment of the society. And that is for that reason, Mr. Speaker, a law reform commission must be as broad-based as possible, both in its appointment process as well as in those who constitute the commission. Mr. Speaker, how can one have a law reform commission without an input from the legal profession? That is inconceivable. Without an input from the judiciary, without an input from the private sector, without an input from the trade union movement, without an input from the religious organizations, without an input from the human rights based organizations, without an input from the trade union movement. That is how our society is composed. And laws are passed by this National Assembly which affect the constituent membership and constituency of all the organizations that I have identified. And what we must always understand, Mr. Speaker, about the law is that the law requires the support of the populace that it is expected to govern. The moment you impose laws that are not in sync with the philosophy and does not enjoy the support and does not coincide with the aspirations of that society that it is expected to govern, that law will be observed in defiance and disobedience. You have to pass laws that a society find generally acceptable and not repugnant. And Mr. Speaker, that is why it is important that in a law reform type of institution, you have the broadest possible representation. This bill, Mr. Speaker, repeals this manifestly absurd appointment process and makes the commission more broad-based and representative of important stakeholders in society. Mr. Speaker, as I said last night on a television program, this bill also demonstrates and illustrates that we do not embrace the style of government that Mr. Ramjatan normally accuses of all. Control freakism, I believe, is the word that he used. Because if we were, we would not, I would not have been standing here and making amendments to a law that is already there, which concentrates in the executive government all the powers of appointment without the resort or the facility of consultation. This here is an example where we are voluntarily migrating and alienating executive power that we already have complements of that size, and we are in a sense extending it to have an involvement and an engagement with those who are extrinsic to our executive government. And this exemplifies, Mr. Speaker, the type of difference in our philosophy and in our style of government. Mr. Speaker, in relation to the qualification of the members, here again we see a palpable misconception and a very untutored view of who comprises of a law reform commission. The previous government felt that a law reform commission should only be comprised of persons with legal qualifications. A manifest absurdity. A proper law reform commission, in addition to legally trained persons, must also have persons trained in social sciences, in the natural sciences, in economics and commerce, and in law enforcement. As part of its mandate will require recommending or drafting laws to meet these sectoral interests. Scientific research may have to be done, social surveys conducted, economic and commercial activities examined to inform legislative policy and indeed law reform itself. Hence, the need to expand qualifications to include personnel trained in these pursuits. This bill seeks to correct these abysmal errors by Clause 3. Mr. Speaker, I will read Clause 3 quickly. Clause 3.3. The chairperson and at least 3 other members of the commission. So you have a 7-member commission for those of us who have read the bill. And the chairman and at least 3 members of the commission shall be persons appearing to be suitably qualified by the holding of or having held an office as a judge of a court having unlimited jurisdiction, etc. Years as an attorney at law for experience as an attorney at law for at least 10 years, experience as a teacher of law in the university for at least 10 years, and then the expansion goes on now beyond these legally trained people. Subject to subsection 3, any other member of the commission shall be a person who has had a minimum of 10 years experience in any of the following fields. A, banking, industry, commerce, or economics. B, social or natural sciences. Or C, law enforcement. So you see how we have moved from only legally trained persons to persons trained in banking, industry, economics or commerce, social and or natural sciences, and in the area of law enforcement. So when a commission of law reform sits, it has these skill sets having regard to the training and qualifications of the persons. Mr. Speaker, the other important addition which the bill makes to the Principal Act is contained in Clause 5 by substituting a new Section 11. In the Principal Act, Section 11 only allows, by Clause 5. And then, Mr. Speaker, Clause 5 lists the various organizations that have to be consulted before membership, before persons are appointed to the commission. They are all listed in the bill, Mr. Speaker. And in addition to the organizations that are listed, we have an amendment that we will soon propose to add another entity to be consulted. And that amendment, Mr. Speaker, will be moved from by one of my colleagues on this side of the House. But I want to recognize the Honorable Deputy Speaker for drawing to my attention that we should include in the entities to be consulted that organization representing indigenous people. So, Mr. Speaker, with those few remarks, I commend this bill to the House. I thank you very much.
Thank you, Honorable Minister. The next person on my list is the Honorable Member Mr. Kemraj Ramjatan. Honorable Member Mr. Ramjatan. Honorable Member Mr. Ramjatan. Before I call on the next speaker, let me just recognize online the Honorable Member Dr. Vishwa Mahadio, the Honorable Member Ms. Annette Ferguson, the Honorable Member Ms. Nina Flo Bess, the Honorable Member Mr. Alistair Charlie.
Thank you, Mr. Speaker. I rise to join my honorable colleague to add my contribution to the Law Reform Commission Amendment Bill number 11 of 2020. Mr. Speaker, having a representative of the National Two Shows Council on the Law Reform Commission is timely and necessary since the NTC, which is the National Two Shows Council, represents 200 plus Amerindian communities across Guyana. Mr. Speaker, the Amerindians have the right, as enshrined in the Constitution of Guyana and under the United Nations of the Declarations of the Rights of Indigenous Peoples, to participate in national decision making in matters which affect our rights. Mr. Speaker, the NTC representative on the Law Reform Commission would truly represent the diverse nature of Guyana's society. Added to that, Mr. Speaker, the Amerindian community needs a representative that would understand the challenges of its people in its own country. Dispensation of information, Mr. Speaker, would be timely to hinterland villages, village leaders, and also in the hinterland regions, since the representative would hold dual appointments, that is on the NTC, National Two Shows Council, and on the Law Reform Commission, that will afford them the opportunity to transmit legal advice, developments, and while gaining full feedbacks. Mr. Speaker, reduction of misinformation and ambiguity in specific regards to law reform. Mr. Speaker, ours was a community that was treated as pariahs in the national landscape under the coalition government. However, Mr. Speaker, the PPPC administrations have treated the Amerindians of Guyana as equals to every citizen of the land. And Mr. Speaker, it is evident today in this August House through this amendment of this bill to have the NTC representative be on the Law Reform Commission. Mr. Speaker, I humbly ask that the amendment of the Law Reform Commission Bill number 11 of 2020 be unanimously supported in the best interests of Guyana's legitimate First Peoples. Mr. Speaker, I thank you.
Thank you very much, Honorable Member Mr. Charlie. I now call on the Honorable Member, Deputy Speaker, Mr. Lennox Schumer.
Mr. Speaker, understanding reform revision and what is needed for the country to move forward cannot be taken in isolation. There must be a context to everything that is presented. And I ask the House's indulgence to impart a little bit of history as we talk about this Law Reform Commission bill. Before this country was formed, Indigenous peoples existed in Guyana. We existed across the Americas without borders. We had territories. Before we started to demarcate the country that separated families across the Americas, not a single person came and say, Indigenous peoples, would you like to be part of a state? In 1814, when Guyana was given to the Brits, no one came and asked the Indigenous peoples, are you willing to be subjects of the Crown? When the laws were made, not a single person came and asked the Indigenous peoples, are you willing to undertake this? Are you willing to have these laws brought upon you? It took, I think, until 1948, and even then, the Amerindian Act, done by Her Majesty, did not address the Indigenous people's needs. It brought us all the way to 2006, with the Amerindian Act coming to life, for us to have a voice. Long, long overdue. It is important that we understand the implications and value of what this Law Reform Commission Act deals with. The United Nations Declaration on the Rights of Indigenous Peoples says that we have a right to self-determination. We have a right to processes that affect our lifestyle, that affect our lives. The Constitution of Guyana, under Article 149G, also enshrines that right. That we are sitting here in this house once again, as we did about 3 weeks ago, debating a 6,000-year issue in the marijuana bill, intellectual property of Indigenous peoples. It is important that we understand the context of what we are doing here today and to ensure that what we do, the people benefit. We have never had, in the history of this country, meaningful engagement to ensure that everything that is done at the highest level, that we have an opportunity to speak on that. We have never had the opportunity to influence policies that affect us. Mr. Speaker, I must commend the Attorney General and the administration at this point for taking such a proactive and ambitious and bold step to ensuring that Indigenous peoples will finally, through this bill, have a voice in the reformation of the legal structures that we have to live with and we have to deal with. Indigenous communities live in conflict in perpetuity, whether it is the Mines Act, the Forest Act, the Lands Act, the Amerindian Act in itself, how they all conflict. All of these things conflict at some point with Indigenous peoples. That we are talking about reform. We are yet to broach a very sensitive topic of constitutional reform we are yet to broach another sensitive topic about the revision or reformation of the Amerindian Act of 2006. And what we have done, or what we are going to see happen through the simple amendment as proposed by my honorable colleague, Mr. Charlie, is for the first time in this country, to see true and meaningful consultation and input from Indigenous peoples. Not only is it timely, Mr. Speaker, it is also long overdue. And it is welcomed, and I thank you.
Thank you, Honorable Deputy Speaker. The next person on our list is the Honorable Member, Mr. Sanjeev Dattadin.
Mr. Speaker, I rise to support the amendments proposed in the Law Reform Commission bill. The amendment is crucial, and indeed, Mr. Speaker, it is necessary if law reform is to be effectively undertaken and we are to achieve the objectives which law reform should indeed achieve. Mr. Speaker, you heard from the Honorable Attorney General. The principal thrust of this amendment is to make the commission that is to be established by this statute more broad-based. It is to make it more inclusive, and it is to allow for the participation of greater society. Mr. Speaker, since Roman times, democracy has been understood to be the will of the people. It doesn't only mean, Mr. Speaker, that once a representative is elected, the wishes of the people are to be ignored. But if we are to reform our laws, and if we are to introduce legislation that are going to govern the people of Guyana, Mr. Speaker, it stands to reason that we should at least consult with them. We should at least listen to what they have to say. Mr. Speaker, this reform must take place with consultation and with an even hand. That, Mr. Speaker, cannot be achieved if all of the power rests in the executive alone. Mr. Speaker, this amendment that is proposed gives effect to Article 12 of our Constitution. Article 12 of our Constitution provides the principal objective of the political system of the state is established in an inclusionary democracy by providing increasing opportunities of participation for the participation of citizens and their organizations in the management and in the decision-making process of the state. Mr. Speaker, those words must have meaning. It must mean that the decision-making process of the state must not exclude the citizens and their organizations. It must not exclude from them the opportunity to contribute. We all know, Mr. Speaker, that we are governed by laws. Every civilized society is. It is obvious to all that the laws in Guyana need updating. The laws in our country must move with the times, as is the popular parlance. We must recognize improvements, developments, and new concepts. This is necessary to reflect how society changes, how society reacts, and it is necessary that we adjust our statutes so that they bring to bear that which the nation needs, that which the nation must have as a tool to progress and to move forward. It must be done if we are to address new challenges in every sphere of society and to remove from the books, our law books, old, archaic, and I dare say, Mr. Speaker, to some extent, useless legislation. The administration of justice requires consultation. The reforms to the judicial system and indeed our statutory regime requires consultation. There must be broad-based representation in that consultation process. Our laws must be for all Guyanese. Our laws must meet the needs of a nation that is growing, and it must reflect the morality of its people. This can only be achieved, Mr. Speaker, if we provide for a law reform commission that consists all segments and all sectors of our society. Mr. Speaker, in 2016, by an act of Parliament, this commission was established. Alas, like so many other things during the last administration, it was left incomplete, save and except for the excesses mentioned this morning by the Honorable Minister, and the commission itself was never constituted. It was a difficult piece of legislation to meet the needs of the Guyanese people. It provided, Mr. Speaker, and it was designed to establish a commission of persons who were all appointed by the President. He had to do so through the minister, but the President ultimately was the appointing force. It consisted of persons with only legal training. The arrogance of such a provision to stipulate to a nation that only the lawyers are capable of coming up with the ideas of what the needs of a society are. It was myopic, it was unfortunate, but perhaps its fatal flaw was that what it sought to do would not have reflected the needs and the morals of a society because it excluded, because it did not provide for any inclusion. The result of such a commission, Mr. Speaker, would have been laws that were really and truly only flowing from the executive arm and from the executive wishes. That is not how legislation should be undertaken, and certainly not the reform. The proposed amendment that has been raised by the Honorable Attorney General, with which I am in total agreement, can be identified as being on two principal planks. One, it provides for the appointment of the members of the commission, and it provides for who should be represented and consulted by that commission. In relation to the appointment of members, Mr. Speaker, the existing legislation that provides for the President alone to appoint persons to be members with the Minister, the previous President, Mr. Speaker, we all know under the last administration, the concentration of power is dangerous. It seemed a common policy. It was sought and exercised even where it did not exist. The unilateral appointment of the chairman of GCOM, Mr. Patterson, is one such incident. That, Mr. Speaker, required the intervention of the highest court, the Caribbean Court of Justice, to correct it in a matter that was brought in the name of the Honorable Minister of Agriculture, Mr. Mustafa. However, Mr. Speaker, let us not escape it. It is not desirable in democratic societies that the concentration of a law reform commission be held only by the executive. The Act, Mr. Speaker, provides for a total of 7 members to be appointed. The Act, the amendment, provides for the President to appoint 2 persons. 5 of those members are appointed by the Minister, the Honorable Attorney General, after he has engaged in wide and meaningful consultation. After consultation, so that society may have an input, so that the voices of the wider society can be heard, so that the consultations can be broad-based. Who are the persons to be consulted, Mr. Speaker? The legislation by Section 3 provides, in the amendment, Section 3, please, Mr. Speaker, the amendment provides the organizations that must be consulted: the Bar Association, the private sector, the trade unions, consumer affairs, religious communities, and by the amendment, the NTC, and you have heard the Honorable Member, Mr. Charlie, emphasize the importance of that. So, Mr. Speaker, not only are we saying in the amendment that there should be broad-based consultations, we are putting in the statute those that are entitled to be consulted, so that they may have a say, so that they can say when they have not been consulted, so they can say that this is what we think, and this is what we would like to see in our laws. The present legislation provides only for persons with legal training. The Honorable Attorney General explained the limitations of having only persons with legal training. But the amendment provides for persons with 10 years experience in fields such as banking, industry, economics, commerce, social and natural sciences, law enforcement. Mr. Speaker, this now allows the Commission itself to be constituted by persons who have considerable experience, 10 years, in the different spheres of society, which makes society function. Natural resources is important to the nation at present. We should have someone with that qualification. Economics, law enforcement, these are all issues which the nation and the people of Guyana want to have considered in their laws. This, Mr. Speaker, is what inclusivity means. We must remember that this commission is charged with reforming our laws, and of necessity, every aspect of our lives will fall for consideration. Every aspect of the lives of every Guyanese will fall for consideration. And for that reason, we should hear from all facets, all spheres. Every nook and cranny of society must be able to contribute. Importantly, Mr. Speaker, the reforming of laws is an expensive process. Funding is usually available. In our particular case, Mr. Speaker, the Honorable Attorney General has alluded to the existence of funding. Mr. Speaker, this legislation goes further. It says very clearly that we can make use of available grants and we could make use of other assistance that is available to us. So we have put in the amended legislation a mechanism that is clear, that we can take advantage of all assistance in reforming our laws to better represent our people and to better represent the wishes of the society. The amendment provides expressly for this inclusion. Mr. Speaker, we must reform our laws. Our laws are outdated in many respects. We must correct this in the shortest possible time at the soonest opportunity. This amendment, Mr. Speaker, provides a framework for a commission to not only engage in this activity of reform, but to achieve this reform that is so desperately needed. Mr. Speaker, I fully support the proposed amendment, and I thank you.
Thank you, Honorable Member, Mr. Datadin. I now call on the Honorable Member, the Minister of the Public Service, the Honorable Member Sonia Parat.
Mr. Speaker, when I was preparing my speech for this debate, it was a legitimate expectation by me that there would be no contestation to the proposed amendment for the Law Reform Commission Act of 2016. And it was for the obvious reason that this bill, Bill number 11 of 2020, satisfies the resounding calls for inclusivity by the public. And it is something that is necessary, and I wholly support the Honorable Attorney General in bringing and tabling this bill in Parliament today. Mr. Speaker, a little bit of research globally will tell you that in any modern society, laws are expected to be reviewed regularly with an aim of being simply understood, accessible, fair, modern, and cost-effective. Any law reform commission acclaimed to have success globally. The fundamental feature of that commission is independence, is inclusivity. Those are two fundamental features that any law reform commission can credit its success to. In Guyana, after revising the laws, the next step would have been to enact the Law Reform Commission Act. That was done in 2016. But in the usual half-baked nature of the opposition, the key factor, which is the commission itself, was never constituted, never established. Yet, exorbitant monies were spent every month without any service in the best interest of the public. Rent was being paid for a building of $800,000 per month. And this was one of the first things that came out in the public when the PPPC took office after August 2nd, 2020. It was wastage, as is every other thing that was being done. And one can only conclude that the lack of constituting a commission that will serve the people, that there was a disinterest in serving the people of this country. The fact that the president had all of the powers through appointment of commissioners only in consultation with the Attorney General showed to the world and to the country that there was an intention to have that chokehold, that political chokehold, that wanting to remain in partisan or playing partisan politics. With all of the calls for government to release control of a commission, this is what the amendments proposed here will do. Mr. Speaker, it's not rocket science to figure out that to have reform in all laws in every sector, that there must be voices heard from different sections of society. Not only heard, Mr. Speaker, but accurately represented and addressed. That is what, again, Sections 3 and 4 of the amendment proposes to do, and it's laid out here clearly. This is not an if or a but. This is a shall. This is mandatory. This is what the process will be. So, Mr. Speaker, this restores confidence in the public that their challenges, their issues will be adequately addressed through their representatives. Those persons who will be appointed on this commission have the responsibility to each section for which they are represented. Mr. President, it is necessary to have, sorry, I'm thinking about the inaugural speech I supposed to do. Mr. Speaker, it is also a feature of the Law Reform Commission Act to develop laws for civil society, for democracy, for the rule of law. In this country, Mr. Speaker, we have seen 5 months prior to the 2nd of August, our democracy almost at a collapse. No one knows it better than us that we need law reform. So, Mr. Speaker, again, I wholeheartedly give my support to the Honorable Attorney General for the proposed amendments to be enacted. That's all.
Thank you very much, Honorable Minister. Honorable Attorney General.
Thank you very much, Mr. Speaker. Permit me to thank the Honorable Deputy Speaker, the Honorable Mr. Schumann, the Honorable Mr. Datadin, the Honorable Mr. Charlie, and the Honorable Ms. Farag for their support and for assisting me in explaining to the House the nature and purport of the amendments. Mr. Speaker, I assume by the absence of the APNU AFC from this debate that they are also supportive of the bill. I know that they cannot come to grips with the reality of standing here and expressing their support for what is obviously a faultless piece of legislation. So rather than stand here and show the Guyanese people that they are supporting the government because they cannot come here and oppose this bill, they have decided to stay away. And I want to take this opportunity, Mr. Speaker, to thank them for their support. Mr. Speaker, at the appropriate time, we will request your leave to pursue a minor amendment. But at this point in time, Mr. Speaker, I respectfully ask that the bill be read a second time.
Honorable members, having proposed the motion, I now put the question that the Law Reform Commission Amendment Bill 2020, Bill number 11 of 2020, published on the 20th of November 2020, be read a second time. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a second time. Thank you. The House will now resolve itself into committee to consider the bill clause by clause. Honorable members, the House is now in committee to consider Bill number 11 of 2020, Law Reform Commission Amendment Bill 2020. And I now propose the question that Clause 1 stands part of the bill. So, I now put the question that Clause 1 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. I now propose the question that Clause 2 stands part of the bill. I now propose the question that I now put the question that Clause 2 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. I now propose the question that Clause 3 stands part of the bill. I now put the question that Clause 3 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. I now propose the question that Clause 4 stands part of the bill. The Honourable Member, Mr. Charlie.
Thank you, Mr. Speaker. Clause 4.1, paragraph 5, by deleting the word "and." Move as an amendment.
Yes, go ahead again, Mr. Charlie.
Also, Mr. Speaker, on paragraph 4.1 in paragraph 6, by substituting the full stop with a semicolon, be moved as an amendment.
The question is proposed. I now put the question that the amendment forms part of the bill. Those in favor say aye. Those against say no. One moment, please. Sorry, Mr. Charlie, I was just double checking the procedure. Before your contribution, I would have had to had the Honorable Member, Mr. Williams, who I have a signature here, second that motion. Mr. Williams? Mr. Charlie had moved. You formally second the motion.
Mr. Speaker, I second them.
Thank you. So, honorable members, we have put the question that clause 4.1 as amended stands part of the bill. Again, those in favor say aye. Those against say no. I also now put the question that, and I'll put them together, that clause. The other two amendments for clause 4.1 stands part of the bill. Those in favor say aye. Those against say no. I now propose the question that section 9(2) forms part of the bill. There is a slight correction. I was putting clause instead of section, so just to, for the records, it was section 2 that I proposed, which was passed, in section 4, which was just amended. Now we turn to page 4, and we propose the question that section 9.2 stands part of the bill. I now put a question that section 9.2 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. I propose the question that section 11 forms part of the bill. I put the question that section 11 stands part of the bill. Honorable Member, Mr. Charlie.
Mr. Speaker, thank you. Clause 4, Mr. Speaker,
Yes.
which also needs an adoption. By inserting after paragraph 6 a new paragraph 7 as follows. Cap 2902. 7. The National Two-Shows Council established under the Amerindian Act be amended, Mr. Speaker. Inserted.
I may have honorable member jump the gun because I put the other two amendments prior. So just for completeness, the honorable member had two other amendments. So let's put the second amendment, that in paragraph 4, by substituting the full stop with a semicolon, I propose the question. I now put the question that that amendment stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. And the insertion the honorable member just mentioned, I propose the question by inserting after paragraph 4 a new paragraph 6, a new paragraph 7. That is, the National Two-Shows Council established under the Amerindian Act. I propose the question. I now put the question that that amendment stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable Minister. Just to sum up, that the bill has been considered clause by clause in committee, and you move the motion that it be reported to the Assembly.
Mr. Speaker, I move that the bill be now read a third time and passed as amended.
We're going to have to propose that motion, then we resume the Assembly, and then put the third.
Very well, sir.
Sorry, hold on a second, Sergeant. So the honorable member did move the motion. You have to take it down. That the bill be reported to the assembly. Those in favor say aye. Those against say no. Honorable Attorney General.
Mr. Speaker, I report that the bill was considered by committee and amended, and I move that the bill be now read a third time as amended.
Honorable members, I put the question that the Law Reform Commission Amendment Bill 2020, Bill number 11 of 2020, be passed a third time as amended. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a third time.
Law Reform Commission Amendment Bill 2020, Bill number 11 of 2020.
Thank you. The next item on our agenda is the Deceased Persons Estate Administration Amendment Bill 2020, Bill number 12 of 2020, published on the 10th of November 2020. Honorable members, we will now proceed with that second reading. The Honorable Attorney General and Minister of Legal Affairs, Mohammed Anil Nandu. Mohabir Anil Nandu.
I get that a lot, Mr. Speaker.
I heard you converted.
Mr. Speaker, one of the characteristics that an avid observer will note regarding bills that are coming from the PPP Civic Administration is that most of these bills, save and except those of a highly technical nature, are bills that have a human face to it, are bills that are intended and are designed to positively impact the lives of the people of our country. And that is a fundamental component of lawmaking. And every time I have a discussion with the Guyana Bar Association or any of the important stakeholder organizations in this country, I invite them to submit to me areas of the law that require amendments because they have become outmoded, because they have become archaic, or because they have lost their conceptual purpose and have now become burden and obstacles rather than regulate and assist the population. The law was never intended, Mr. Speaker, to become an obstacle to human progress. The law was conceptually designed to enhance and regulate and advance human progress and assist people in the conduct of their everyday life. Mr. Speaker, it is against that backdrop that I speak on the bill that is before this House. It is small in its form, but I dare say, Mr. Speaker, it has far-reaching and very positive ramifications and implications for the widest cross-sections of our population. Any lawyer who has been in active practice, and most persons who may be listening to us here today, can relate and would be able to relate directly to this piece of legislation. Mr. Speaker, as you may know, when a person dies, the assets of that person forms part of that person's estate, and as the legal entity that holds that assets or those assets of a deceased person by operation of law until someone duly authorized to deal with those assets are appointed. The process by which such a person is to be appointed is a legal process. If the deceased dies intestate, meaning if the deceased dies without leaving a will, then the person next authorized by the law to apply for that letters of administration has to by law approach the High Court and request that the High Court makes an order granting what is called letters of administration for that deceased person's estate. If the deceased person dies testate, meaning that he dies leaving a will, well, the will normally appoints an executor, and that executor is required to apply again to the High Court for probate to be granted in relation to that will. And it is only when either of these two instruments are appointed, the letters of administration and the probate, that the person to whom they are granted is authorized to stand in the shoes of the deceased person and deal with the assets of that estate of the deceased person, subject, of course, to certain legal principles which protect the interests of the beneficiaries of that estate. Mr. Speaker, so if the deceased person has a car, no one can sell that car or can apply for insurance for that car or can apply for certificate of fitness for that car unless that person obtains either that letters of administration or that probate, as the case may be. If the deceased person has monies in the bank, those monies cannot be withdrawn or cannot be touched for any matter whatsoever unless that grant of probate is presented to the bank or that letters of administration is presented to the bank by the person to whom it is granted. Only then would the bank allow a withdrawal of monies from the deceased account. In other words, the assets of the deceased remains frozen until these processes are made and these two documents or instruments are granted. The problem that we face and society face realistically is that this process to which I am referring to is a very expensive one. One has to retain a lawyer, one has to go and compile all the assets, one has to have them valued by a certified valuation officer, one has to go to the Guyana Revenue Authority and have all the estate, the assets examined in an inventory, and then one also has to compile the liabilities, and then based upon the net value of the estate, one has to pay estate duties, and then make the application for the grant to which I'm referring to, either probate or letters of administration to the High Court. Then a judge has to examine that application, and then the document or the application is granted. Mr. Speaker, this process that I have just outlined is a very expensive one and costs an average at a minimum $200,000 to $300,000, and that is the lowest I have gone, and that is the smallest of estates. It can, on the other scale, on the other end of the scale, run into millions, depending upon the value of the estate, because the lawyer's fees vary in accordance with the size of the estate. Then, Mr. Speaker, the time that it takes to get all the things that I have spoken about. Sometimes you can't find a transport for a property. You have to then apply to get a certified copy of a transport. You may have a transport lodged at the bank. You have to get a certified copy from the court. You may not be able to find a registration for a vehicle. You have to go to GRA and get a certified copy of a registration. So to prepare the application that one has to lodge with the court is by itself an expensive exercise, and I have not included that in the lawyer's fees, which I quoted earlier. And that by itself, Mr. Speaker, can be a very time-consuming exercise. And when you get that and you make that application, then there is another long and protracted delay before the court grants the application. Yesterday only, Mr. Speaker, only yesterday, a person whom I know personally asked my assistance to intervene because her husband died. The application for letters of administration was filed since 2018, and to date it has not been granted. Her husband has some money in a bank account, and the only child of the family is in university and is in dire need of those monies to pay for his tuition. And the mother has made the application to the court since 2018 for the letters of administration to be granted. And as of yesterday, it was not granted. And my intervention was sought. This is 2021. So right there, Mr. Speaker, I am giving you a live example of the time that it takes for one of these applications to be granted. And then I spoke about the time it takes to make it and to prepare the application itself to take to the court. In those circumstances, Mr. Speaker, we have persons right across our population, in particular, poorer people, our working people, our more vulnerable, have had to endure tremendous hardships because of this position in the law that restrains them or prohibits them from touching the assets of a deceased until this grant is made. So, Mr. Speaker, a man may have money in the bank, $500,000, let us say, a poor person, poor family, and that's all the money that the family has. The family cannot go to the bank to withdraw that money even to do the funeral. And that may be all the money that they have to do the funeral. They have to wait until that grant is made by a court. And they may not even have money to do even that. And the worst case scenario, Mr. Speaker, is where the money in the bank is so minuscule, so small, and then again it's not so small but it's lower than the cost, it's smaller than the cost to make the application to get the money. So you have $300,000 in the bank, but the cost to get the $300,000 might be $400,000. So it is left in the bank. And Mr. Speaker, I had a meeting with the Banking Association late last year, and they drew to my attention the number of accounts which have been rendered dormant with monies in it simply because persons have refused, omitted, or neglected to withdraw them after the death of the deceased. Mr. Speaker, our law, which is nearly 100 years old, the Deceased Person Administration of Estate Act, which is the principle to this act, 100 years ago recognized the hardships which I have just outlined. And in the principal act, it accepts estate of a certain value, I think $250 or something like that. And made certain exceptions in relation to those estates of that size, and also allowed for the withdrawal of a small sum of money. Now it is small, but at that time it would not have been small without the grants that I'm speaking about. This bill, Mr. Speaker, that is before this House, along with some amendments which I will propose at the appropriate time, seek, Mr. Speaker, cumulatively to alleviate the hardships to which I have alluded, and allows for a dispensation of grants of probate as well as letters of administration. So, Mr. Speaker, in relation to estates that are $750,000 in value, the bill that we are proposing along with the amendments dispenses with the need for a probate to be granted in the event of the deceased person leaving a will, or for letters of administration if there is no will. Once the net value of the estate is $750,000, then you do not require letters of administration or probate. And that applies, Mr. Speaker, to estates which the public trustee is also by law required to administer. So it applies firstly to intestate estates, it applies to testate estates, and it applies to estates over which the public trustee and other organizations may have responsibility in relation to. The second important component of the bill, Mr. Speaker, is in relation to the bank accounts. Whether the deceased dies testate or intestate, a duly authorized person, and in terms of if he dies intestate, meaning without a will, of course the rules of intestacy creates a hierarchy of persons who are entitled in that order to apply. Starts with the spouse, and then with the children, if there is no spouse, and if there is no children, then sibling, parents, and then sibling. It's all outlined in the Civil Law Act in the order in which they take priority. So any one of those persons can go to the bank and withdraw from the deceased account up to $750,000 immediately by the presentation of documents that the bank will consider relevant. Obviously, the death certificate of the deceased. Obviously, a document that will establish to the satisfaction of the bank that you are one of the persons duly qualified. Your marriage certificate if you're a spouse. If you're a child, then your birth certificate with the name of the deceased stated as the father. And significantly, Mr. Speaker, we have already amended in 2014 when we were in government the law to allow for a common law spouse to benefit from the estate of her deceased, a deceased spouse, in the same fashion that a married woman would have. We have already corrected that deficiency in the law. So, here, a married wife or a common law wife would be of equal standing if such a person is to approach the bank. Also, if the deceased died testate and there is an executor, then the executor will go present himself, provide the documents requisite, and will be allowed to withdraw up to $750,000. Significantly, Mr. Speaker, unlike the Principal Act, where it had confined the withdrawal to a limit, if the account was of that limit, in other words, it only applied to small accounts, in the amendments that are coming, that limit, Mr. Speaker, has been expanded so that it applies to all accounts, all bank accounts, but of course, you are only entitled to withdraw $750,000. So let us say that the deceased person has $100 million. Then one can withdraw $750,000 immediately without the grant of probate or letters of administration. So, Mr. Speaker, this bill and the accompanying amendments, which I will ask at the appropriate time that we consider, presents a great reprieve against the hardships that are imposed on persons, as I said, especially the poorer classes of people in our society who may have great financial constraints and difficulties when the unpredictable phenomenon of death raps on the door. This bill, Mr. Speaker, in my humble and considered view, is long overdue and will help a wide cross-section of our population. And, Mr. Speaker, it also again manifests and demonstrates that the PPP Civic Administration has a legislative agenda that is not sterile, that is not reactive to international organizations, but is and caters for and addresses the concern of the people of our country, every sector of our population. And all these bills that are on the order paper, if Your Honor is to look at them, you will see the deep human element in all of them. The Small Businesses Bill deals with small business, human beings right away. The Hire Purchase Bill, when we get to debate that. All of them, people at heart. The amendment that we made to the Narcotics Act, people at heart. The Law Reform Commission, the way it was expanded to allow for all of our people to be consulted. So we have an agenda, Mr. Speaker, a parliamentary legislative agenda that the population can relate to. We do not make laws in isolation. The other side is not here because I would have asked them to point to one law that they passed from 2015 to 2020 that had a people component to it. I was racking my brain last night. I can't think of one. They passed a whole series of AML CFT bills, which were all draconian, as Bishop said, but they were to satisfy technical requirements. The law that they passed, though, the series of laws that they passed were to impose taxes on the backs of the people. That's the type of law that they have a specialty in passing. And also the type of laws that allows the GRA to invade people's bank accounts without notification. The law that allows you, the GRA man, to stop you at the airport if you owe taxes. That's the kind of law. And you see, Mr. Speaker, the juridical and philosophical content of the type of legislation. On that side, it is oppressive and repressive. On this side, Mr. Speaker, it's affectionate and love. And that is the difference between the two. So, Mr. Speaker, I ask respectfully that this bill and be read a second time, and at the appropriate stage, Mr. Speaker, I will respectfully invite us to consider the amendments which I am proposing. I thank you most kindly, sir.
Thank you, Honorable Attorney General. I call on the Honorable Minister of the Public Service, the Honorable Sonia Parag, to make her contribution.
Mr. Speaker, the Honorable Attorney General just alluded to another bill that carries a human face. The common thread with all of the bills that are presented by this government has a human face, it has a human component that is relative, that can connect with the people of this country. The amendments to the Deceased Persons Estate Administration Act, though looks minimal, carries a huge impact on a large section of our society. Being someone who has encountered many clients in private practice, and I'm most certain that the Honorable Attorney General and the other lawyers that are in Parliament here today would have experienced this. 90% of your clients who come to deal with small estates, you have to end up doing it pro bono because the cost is so much to go through the legal process of accessing the estate that they are entitled to. It deters them from doing so, and the lawyers having to end up doing the work for free because you want to assist. So the amendments proposed in this bill will have a very far-reaching effect, Mr. Speaker. Many times, small estates are left inaccessible to the heirs, and many times the process is so long. The Honorable Attorney General spoke of an experience that he had of 2 years. Sometimes it's longer than that, Mr. Speaker. Persons die waiting to access something that they are entitled to get. So this proposed amendment is to eliminate or give relief to those persons who has to get what they should get. Mr. Speaker, the process has not changed legally very much. And therefore, persons are really constrained by the cost, by the time, and this is something that should have been looked at in the last 5 years. It is something that was necessary, something that could have caused ease to so many persons. People have to come from Maikoni, come down from a Region 5 to Georgetown, pay their transportation costs so many times. They have to go and pay taxes, get compliance, which takes a percentage of the estate. The lawyer's fees, the percentage of the estate. People just don't have money, Mr. Speaker. And the fact that they are trying to access something as small as an estate of $750,000, which is the proposed amendment, it means that they are in need of finances. For many reasons. One, perhaps to have their loved one be sent off in the best possible way. Two, that they have other needs for that money. The fact that they can't access it is unacceptable. It is unacceptable. And it is for this reason that, again, I support this bill, because I know that this is something that will give relief to the poor people. It is a pro-poor bill. And so, Mr. Speaker, I don't really have much to say on this bill except to say that anyone with an ounce of sense will know that this will bring relief. Just one of the measures that will bring relief. In saying that, Mr. Speaker, I don't believe I have anything much to add yet. The Honorable Attorney General would have stated so much on what the proposed amendments are.
Thank you very much, Honorable Minister. The Honorable Minister of Education, the Honorable Priya Manager.
Thank you very much, Mr. Speaker. Mr. Speaker, it gives me great pleasure to stand here and support the passage of this amendment, an amendment that should see the support from every member of this House who claims to be representing people in this country. The character of a government, I think, sir, could be judged from how it treats not only large numbers, not only masses, not only the people who will celebrate relief and goodness with letters in the newspapers and perhaps even thank you cards and thank you billboards, but by persons who need it so much that they have no, and are so poor, perhaps downtrodden, that they have no means even to celebrate goodness that is brought to them, that they have little means to even represent that they need that kind of relief. A government can be characterized, sir, by how it treats its most needy, as equally as how it treats its loudest members of society. And this government is committed to making sure that we address the needs of everybody. So there are business people who have great wealth and who help to generate wealth in this country, who need us and need our interventions in this House to pass laws and implement policies. But there are people who we will never hear from, who really need us. And that is the category of persons this amendment is going to serve. We heard from the Attorney General what it's really about. It is an amendment that seeks to offer to poor persons who have died leaving, or whose families have had a deceased die, leaving $750,000 or less in the bank. That alone tells you the category of persons we're dealing with. Persons who have less than $750,000 in their estate. This is not new to the law. When the law first was made, it was recognized that we should not burden persons with a small estate with the hassles of getting letters of administration if you die intestate, or probate if a deceased dies leaving a will, because that involves not only the expense of a lawyer that the Attorney General spoke about, and it's usually 5% of a large estate, and if it's not a large estate, and like he says, it starts at 150, 300, 500, depending on the lawyer. And we have persons who, it's not just the lawyer's fee. There's an estate duty that has to be paid, now called processing fees, right, to the government. There are valuations that have to be had. There are bank statements that have to be had. All of these things cost money. Affidavits that have to be sworn, and so on. That is very burdensome financially. But the running around to get to the process is also extremely burdensome for a grieving family. You have to come to central points. The magistrates' courts do not deal with estates. So it's the high courts. And we know we have high courts in only 3 places in Guyana: Berbice, Essequibo, and Georgetown. And in fact, all the estates come to Georgetown, although you can visit your lawyer in your particular area. So this becomes very burdensome for our dear citizens. The Principal Act recognizes that and catered for it. But because it's such an old act, it catered for estates that were not more than $1,000, well, that were $1,000, catered for $1,000 estates. We're now raising that to $750,000. And that underscores, sir, how very important a law reform commission, the bill we just passed in the Assembly, is needed. These are the kinds of holistic changes we have to look at. $1,000 will mean nothing to a grieving family at this point in time, and that's something we can fix, and fix easily, and that's what we seek to do here today. So this bill, Mr. Speaker, is going to allow persons who die testate, that is, who died leaving a will, persons who died intestate, that is, without a will, or persons who died leaving a will but not naming an executor or following the procedures of our law. It would allow their beneficiaries to access up to $750,000 from their estates to be able to do several things. Many persons actually need that money urgently to bury their dead, their loved ones, to dispose of their loved ones. And many persons, once the breadwinner is gone in the house, needs emergency money right away to be able to cater for the shock that is created in their family when that breadwinner goes. So this is going to serve our families. It's going to serve our poor. It's going to serve people who are already in grief. Mr. Speaker, it allows for, and there is an amendment that I believe the Attorney General is going to propose from the floor, well, a few amendments. So this allows first the applicant, which would be the beneficiary of the estate, and the Attorney General went through the various levels of beneficiaries, the principal beneficiary to receive up to $750,000 from the bank if the estate has more. So even if the estate has $3 million and a deceased dies and has $3 million in the bank, this amendment allows the beneficiary to go and receive at least $750,000. It also allows for the beneficiary to receive all of the money once it is under $750,000. The amendment will also cater, sir, for people who die testate. That was not in the previous bill that was laid before the House, and that was inadvertence. So we're making no distinction between the person who dies testate and the person who dies intestate by these various amendments. Mr. Speaker, there are a few other things that would have to be done. If someone is going to the bank, they would have to show proof of death. They would have to show kinship. How are you related? So if it's a wife going to claim this, she has to show proof of death as well as her marriage certificate. Minister Ben is going to become very important in this process because it makes no sense If we come here and pass laws, but they cannot be effected, and death certificates take forever to be issued. So we'd have to put in place, and I truly hope this conversation will be had as soon as possible after this bill is passed, the ability for these types of applicants to be able to access a death certificate almost immediately. Almost immediately. We have to do that, or this amendment will make no sense to them. The urgency that we believe people need money in these circumstances would be diluted because of other logistical nightmares that they're usually faced with sometimes with these services. And so we have to look at this holistically even after it is finished. Walk this through to see what are all the obstacles and hurdles that would lay in the path of an applicant to determine how we can make it as easy as we want to make it. Mr. Speaker, I remember the last amendment we made under the Deceased Persons Estate Administration Act, and that was to allow, we had made a lot of very progressive changes regarding common law wives, what we call common law wives, who are defined to be a single woman living together with a single man in excess of 5 years. We had made a lot of amendments, but we failed to make one. And that was to allow a common law wife to make applications under the Deceased Persons Estate and Administration Act, the principal act that we seek to amend today. And it was this Attorney General during the 2011 to 2015 period that brought that to the House, where we demonstrated how caring we were to the common law wife and how much of a friend we are to families by making that amendment. 5 or 7 years later, we come back to make an amendment again for people who are disadvantaged or who would be disadvantaged by this particular law. Sir, like I said, you can use government to trample on people. You can use government to speak down to people. You can use government to try to rig elections. You can use government to install unilaterally GCOM chairmen, or you can use government to change lives for the better. This bill, sir, will change people's lives for the better. Ironically, Mr. Speaker, many of the people who will benefit from this probably never even realized how easy it would be for us to change this for them. We know how easy it is, and we're here. We're here less than 7 months in office, making a change that will impact people in this country who have no recourse and who need it most. And we commit to the people of Guyana that this will be the characteristic underlying our governance. Whatever it is we do, we will do it to make sure it serves people, so that people benefit, so that families benefit, so that our communities are stronger, so that our systems improve. And this here, Mr. Speaker, is going to offer that kind of relief. It is aimed specifically, or mainly, because there is provision for the person who dies with a larger estate but immediately needs some money, but it is aimed mainly to address the people who die or the families who have loved ones who died, leaving very small estates. I am absolutely certain the banks would be happy with this also. I am aware of many persons who had 200,000 in the bank after years and years of saving. $300,000 in the bank, they die leaving that there, and their families have no wherewithal to get it out. So it's left there in the bank. How unjust is that? That is just so unjust. And it might be a father who died, leaving a mother and 3 children, and she's thrown into financial shock because of that debt, and she cannot access that. We are changing that today. We're changing that today. And so I take great pleasure in commending this bill to this House and to say, and in saying that this is the kind of change legislatively the PPPC will be looking to bring to this country. I thank you, sir.
Thank you, Honorable Minister. Honorable members, before I take the suspension, I just want to urge you that we're going to return at 1:30. The challenge we've been having is a quorum in the assembly and online to restart. So, honorable members, I would appreciate if we could get back here before 1:30 so we can resume the debate on the deceased persons bill. Honorable members, I now take the suspension.